I never thought buying my dream house in Scottsdale, Arizona, would lead to a lawsuit over something as ridiculous as footprints in my own backyard. But here I was, sitting across from a judge while the HOA president tried to ruin my life over something that shouldn't have mattered to anyone but me. My name is Peter Nichols, and I had just moved into the Saguaro Heights community 6 months earlier. The neighborhood was beautiful, with pristine desert landscaping, adobe-style homes, and mountain views that made every sunset feel like a painting. I had saved for years to afford the down payment on my 3-bedroom house, and I was finally living the life I had worked so hard to build. I ran a small consulting business from home, which meant I spent most of my days in my office overlooking the backyard. The previous owners had installed this gorgeous, decomposed granite path that wound through native plants and cacti, and I loved everything about the property. The trouble started on a Tuesday morning in March when I decided to water my Mexican sage plants before the afternoon heat set in. The ground was still damp from an unexpected spring rain the night before, and as I walked along the path to reach the drip irrigation controls, my shoes left slight impressions in the softened granite. I thought nothing of it. The material would dry, the footprints would fade, and life would go on. I had no idea that Karen Whitmore, the HOA president who lived 3 houses down, had apparently been watching my property like a hawk. 2 days later, I found a violation notice taped to my front door. The letter was printed on official HOA letterhead, complete with the neighborhood logo and a long list of board members at the bottom. I read it standing in my doorway, my coffee getting cold in my hand as I tried to process what I was seeing. According to the notice, I had violated Section 7.3 of the Community Covenants, Conditions, and Restrictions, which stated that all landscaping must be maintained in pristine condition at all times. The specific violation cited was visible disturbance to landscaping materials causing unsightly appearance and diminished aesthetic value to the community. I walked around to my backyard and stared at the path. The footprints were barely visible anymore, just faint shadows in the granite that you would only notice if you were specifically looking for them. They would be completely gone within a day or two as the material settled and dried. This had to be a mistake. I pulled out my phone and called the number listed on the violation notice. A woman answered on the 3rd ring. Saguaro Heights HOA, this is Karen Whitmore speaking. Hi, this is Peter Nichols from 4782 Desert Vista Drive. I just received a violation notice about footprints in my backyard, and I think there might be some confusion. No confusion at all, Mr. Nichols. Her voice was sharp and clipped, like a teacher scolding a student. I personally inspected your property and documented the violation. The footprints are clearly visible and constitute damage to your landscaping. But they're just footprints from me watering my plants. They'll disappear in a day or two when the material dries out completely. That's irrelevant. The violation exists now, and you have been assessed a fine of $250. Payment is due within 30 days. I felt my jaw tighten. $250 for walking in my own backyard, for violating the CCRs, Mr. Nichols. Every homeowner agrees to abide by these rules when they purchase property in Saguaro Heights. If you have concerns about the regulations, you're welcome to attend the next board meeting and voice your objections. However, the fine stands. This is completely unreasonable. I should be able to walk in my own backyard without being fined. The fine is for the violation, not for walking. I suggest you review your CCRs more carefully. Good day, Mr. Nichols. She hung up before I could respond. I stood there holding my phone, feeling a mixture of anger and disbelief. I had heard horror stories about HOAs before moving in, But the neighborhood had seemed so normal, so reasonable during my house hunting process. The seller had mentioned that the HOA was active but fair, and the disclosure documents had shown modest monthly dues and standard rules about maintaining property values. Nothing had prepared me for this level of absurdity. I spent the next hour reading through the entire CCR document, all 47 pages of it. Section 7.3 did exist, but the language was vague and clearly intended to prevent major landscaping damage, not temporary footprints. The section talked about maintaining landscaping materials, but there was nothing specific about footprints, walking paths, or normal use of one's own property. I took photos of my backyard from every angle, documenting how minimal and temporary the footprints actually were. That evening, I drafted a formal appeal letter to the HOA board. I explained the situation, provided the photos, and argued that the violation notice was an overreach of the board's authority and a misinterpretation of the CCRs. I cited the specific language in Section 7.3 and pointed out that normal use of one's property could not reasonably be considered a violation. I delivered the letter to the HOA management office the next morning. 2 weeks went by without any response. I checked my mail daily, expecting to receive some acknowledgement of my appeal or, hopefully, a notice that the fine had been withdrawn. Instead, I received a second violation notice, this time with an additional $50 late fee because I had not paid the original fine within the first 15 days. The new total was $300. I called the HOA office again, and once again got Karen Whitmore on the phone. "I sent an appeal letter 2 weeks ago," I said, trying to keep my voice calm. "I haven't received any response." "Your appeal was denied," she said flatly, "when I never received any notification. The board reviewed your appeal at our meeting last Tuesday. The decision was unanimous to uphold the violation and the fine. You should have received a letter." "Well, I didn't receive anything. And how can you add a late fee when my appeal was still pending?" "Appeals don't stop the clock on payment deadlines, Mr. Nichols." That's clearly stated in Section 12.5 of the CCRs. You now owe $300, due within 15 days. This is absolutely ridiculous. I'm not paying a fine for walking in my own backyard. Her voice turned icy. "Then you'll face additional penalties, including potential legal action and a lien on your property. I suggest you take this matter seriously, Mr. Nichols. The HOA has full authority to enforce our rules, and we will not hesitate to pursue collection through the courts if necessary." "Maybe I'll see you in court then, because I'm not paying for this nonsense." I hung up, my hands shaking with frustration. I had never been the kind of person to cause trouble or pick fights, but this situation was so fundamentally unjust that I couldn't just roll over and accept it. I started researching HOA law in Arizona, spending hours reading statutes and court cases. I learned that HOAs in Arizona had broad authority to enforce their rules, but that authority wasn't unlimited. They could be challenged if they acted arbitrarily, capriciously, or in bad faith. They also had to follow proper procedures for violations and appeals. 3 days later, I received another letter from the HOA. This one informed me that, because I had not paid the fine, additional penalties were being assessed. The total was now $400, including administrative fees and continued late charges. The letter also stated that if I did not pay within 7 days, the HOA would file a lien against my property and potentially begin foreclosure proceedings. I knew they were trying to intimidate me, but the threat of losing my house over footprints was terrifying regardless of how absurd it seemed. I decided it was time to hire an attorney. I couldn't afford expensive legal bills, but I also couldn't afford to lose my home. I started calling lawyers who specialized in HOA disputes. The first 3 attorneys I spoke with either didn't take cases like mine or quoted retainer fees that I couldn't afford. The 4th call was to Mitchell Anderson, a solo practitioner who had recently left a large firm to focus on homeowner rights cases. His website featured several successful cases against overreaching HOAs, and when I explained my situation over the phone, he actually laughed. "Footprints," he said. "They're trying to fine you for footprints in your own backyard." "Unfortunately, yes. And now they're threatening to foreclose on my house." "How much are they claiming you owe?" $400 as of the latest letter, but it seems to increase every week." "And you never actually damaged anything?" "These were just temporary marks from normal use of your property." "Exactly. You could barely even see them after a day." "This is one of the more ridiculous HOA cases I've heard, and I've heard a lot of ridiculous ones. I'd be happy to take your case. My retainer is $1,500, and I charge $200 an hour after that. But here's the thing: if we win and can prove the HOA acted in bad faith or violated proper procedures, we can ask the court to make them pay your attorney fees under Arizona law." The retainer was steep, but Mitchell's confidence and experience were exactly what I needed. I agreed to hire him, transferred the money that afternoon, and immediately felt a weight lift off my shoulders. I wasn't alone in this fight anymore. Mitchell worked quickly. Within 3 days, he had drafted and filed a response to the HOA's collection attempts, formally disputing the fines and requesting a hearing before the board. He also sent a strongly worded letter to Karen Whitmore and the HOA board, outlining the questionable legal basis for the fines and warning them that continued harassment could result in counterclaims for abuse of process and intentional infliction of emotional distress. The HOA's response was to schedule a hearing for 2 weeks later. The notice arrived certified mail, informing me that I had the right to appear before the board to contest the violations and fines. Mitchell advised me to attend and let him do most of the talking. The hearing was held in the community clubhouse, a nice facility with a pool, gym, and meeting rooms. I arrived with Mitchell at 6:30 in the evening, finding the board already seated at a long table at the front of the room. Karen Whitmore sat in the center, flanked by 4 other board members, 2 men and 2 women, all appearing to be in their 50s or 60s. About a dozen other residents sat in chairs facing the board, apparently there to watch the proceedings or wait for their own agenda items. Karen called the meeting to order with a sharp rap of a gavel. She went through several mundane items, first approving minutes from the previous meeting, discussing landscaping bids for the common areas, addressing a resident's request to paint their front door a slightly different shade of beige. Then she got to my case. Next item is the appeal of violations and fines assessed against Peter Nichols of 4782 Desert Vista Drive. "Mr. Nichols, you and your attorney may approach." Mitchell and I walked to a small table facing the board. Mitchell set down his briefcase and pulled out a folder of documents. "Good evening, members of the board. I'm Mitchell Anderson, representing Mr. Nichols in this matter. We're here to contest the violations and fines that have been improperly assessed against my client for the alleged offense of having footprints in his backyard." Karen's expression didn't change. "The violations were properly assessed according to our CCRs. Mr. Nichols damaged his landscaping materials, creating an unsightly appearance. With respect, Miss Whitmore, Temporary footprints from normal use of one's property do not constitute damage and cannot reasonably be considered a violation of the landscaping maintenance provisions. The CCRs, specifically Section 7.3, were clearly intended to address actual damage or neglect, not the inevitable and temporary marks that occur when a homeowner walks on their own property to perform maintenance. One of the other board members, a man with gray hair and glasses, leaned forward. "Are you saying homeowners should be free to damage their landscaping without consequence?" "I'm saying that what occurred here was not damage. My client was watering his plants, walking on the decomposed granite path that was installed specifically for walking. The footprints were barely visible and disappeared within 48 hours. This is normal use, not damage or neglect." Karen pulled out her own folder. "I have photographs of the violation taken at the time of my inspection. The footprints were clearly visible and detracted from the aesthetic appearance of the property." She passed copies of the photos to the other board members. Mitchell glanced at the photos and actually smiled. "These photos actually prove my point. The marks are so minimal that they are hardly visible even in direct sunlight. And more importantly, they were temporary. The board is attempting to assess hundreds of dollars in fines for something that resolved itself naturally within days, if not hours." "The temporariness of the violation is irrelevant," Karen said. "The violation existed at the time of inspection, and that's what matters." "Actually, it's extremely relevant," Mitchell countered. "The purpose of HOA regulations is to maintain property values and community standards. Temporary, minor, unavoidable marks from normal property use do not impact property values or community standards." If the board's interpretation of the CCRs were correct, every homeowner would be in violation every time they step outside, every time it rains, every time a bird lands on their property. It's an absurd interpretation that cannot stand. A woman on the board raised her hand slightly. "But if we don't enforce our rules consistently, doesn't that open us up to claims of selective enforcement?" "Enforcement should be consistent," Mitchell agreed, "but it should also be reasonable. There's a difference between a homeowner who lets their landscaping fall into disrepair and a homeowner who leaves temporary footprints while maintaining their property. The CCRs give the board discretion to determine what constitutes a violation. That discretion should be exercised reasonably, not used as a weapon to harass homeowners over trivial matters." Karen's face flushed red. "This board does not harass anyone, Mr. Anderson. We simply enforce the rules that all homeowners agreed to follow." "Then let me ask you this, Miss Whitmore, how many other homeowners have been cited for footprints in their yards? Have you conducted similar inspections of other properties?" "We respond to complaints and conduct routine inspections as needed." "That's not an answer to my question." "Have you cited any other homeowner for footprints?" Karen's jaw tightened. "Each case is evaluated individually." "So that's a no," which suggests that this enforcement action is selective and potentially motivated by personal animus rather than legitimate community concerns. "That's absurd," Karen snapped. "I have no personal issue with Mr. Nichols. I don't even know him." "Then why did you personally inspect his backyard? Why did you take photographs of barely visible footprints? Why did you assess fines that have now ballooned to over $400? And why, when my client filed a proper appeal, did the board deny it without even contacting him to discuss the matter?" The gray-haired man cleared his throat. "Miss Whitmore, did we send Mr. Nichols a letter about the appeal decision?" Karen shuffled through some papers. "It should have been sent. That's standard procedure." "Should have been, or was. I'll have to check with our management company." Mitchell pulled out a document from his folder. I've already checked. I submitted a records request to your management company last week. They have no record of sending any correspondence to Mr. Nichols about his appeal. In fact, they have no record that the appeal was ever formally considered by the board. Miss Whitmore told my client over the phone that the board had denied his appeal, but there's no documentation of that decision. No minutes from a meeting where it was discussed. Nothing. The other board members were looking at Karen now with expressions that ranged from confused to concerned. The woman who had asked about selective enforcement spoke up. "Karen, is this true? Did we actually vote on Mr. Nichols' appeal?" "I made the decision based on my authority as president," Karen said stiffly. "The appeal had no merit, so I saw no reason to waste the full board's time." "But the CCRs require appeals to be heard by the full board," Mitchell said, pulling out another document. Section 12.6 clearly states that any homeowner has the right to appeal a violation to the full board, and the board must vote on the appeal within 30 days. Miss Whitmore acted unilaterally, without proper authority, and then assessed additional fines based on an appeal decision that was never actually made by the board. The room was silent for a moment. The other board members were exchanging glances, and I could see Karen's face getting redder. The gray-haired man spoke again. "Karen, I think we need to discuss this as a board. Can we take a short recess?" Karen banged her gavel. 5-minute recess." Mitchell and I stepped outside while the board huddled at their table, having what looked like a heated discussion. I could see Karen gesturing emphatically while the other members shook their heads or frowned. "That went well," Mitchell said quietly. "She doesn't have a leg to stand on, and the rest of the board is figuring that out. What happens now? Best case, they withdraw the fines and we're done. Worst case, they dig in their heels and we end up in court. But if they're smart, they'll cut their losses." We waited outside for nearly 15 minutes before we were called back in. The board members had rearranged themselves slightly, and Karen looked furious. The gray-haired man, who I learned was named Robert, spoke first. "After discussion, the board has decided to withdraw the fines against Mr. Nichols and remove the violations from his record. We apologize for the confusion and the procedural errors in handling this matter." I felt relief wash over me, but Mitchell wasn't done. "We appreciate the board's willingness to correct this situation. However, my client has incurred substantial attorney fees defending against these improper charges. Will the HOA be reimbursing those fees?" Robert looked uncomfortable. "We'll have to consult with our attorney about that." Arizona Revised Statutes Section 33-1807 allows a court to award attorney fees to a homeowner who successfully challenges an HOA action that was not substantially justified. While I'm glad we've resolved the underlying violation, the fees my client has incurred are a direct result of the HOA's improper actions. If the board is unwilling to reimburse those fees voluntarily, we'll have to seek a court order. Karen stood up abruptly. "This is extortion. You're trying to shake down the HOA for legal fees over a minor dispute. It's not a minor dispute when you're threatening to foreclose on someone's house over footprints," Mitchell shot back. "And it's not extortion to seek compensation for fees incurred due to your improper actions. My client did nothing wrong, yet he's had to hire an attorney to defend himself. That's on you and your overreach." Robert held up his hands. "Let's all take a breath. Mr. Anderson, what are we talking about in terms of fees?" "My client has paid me $1,500 so far, and I've billed approximately 6 additional hours at $200 per hour. That's $2,700 total." I saw several board members wince at the number. The woman who had asked about selective enforcement spoke up. "I move that we reimburse Mr. Nichols for his attorney fees, given the procedural errors in this case. Second, said another board member immediately. Karen looked like she wanted to argue, but Robert quickly called for a vote. 4 board members voted yes. Karen abstained, sitting with her arms crossed and a scowl on her face. The motion passes, Robert said. Mr. Nichols, we'll issue you a check for $2,700 within 30 days. Again, our apologies for this situation. Mitchell thanked the board and we left the meeting. In the parking lot, I turned to him with a huge grin. That was incredible. I can't believe they actually agreed to pay. They didn't have much choice. If we had gone to court, they would have lost badly, and the legal fees for both sides would have been much higher. They made the smart decision, even if it took them a while to get there. Thank you so much. Seriously, I don't know what I would have done without your help. That's what I'm here for. And honestly, this was one of the more satisfying cases I've worked. There's nothing I enjoy more than putting an overreaching HOA president in their place. I drove home that night feeling vindicated and relieved. The stress of the past month was finally lifting, and I could go back to enjoying my house without worrying about ridiculous fines or threats of foreclosure. I thought that was the end of the story. I was very wrong. 2 weeks later, I received another violation notice. This one cited me for having weeds in my landscaping. I went outside to look, and sure enough, there were a few small weeds growing near my back fence, probably sprouted after the spring rains. They were minor, the kind of thing that any homeowner would pull during their weekly yard work, but apparently they constituted a violation. The fine was $150. I took photos of the weeds and sent them to Mitchell along with the violation notice. He called me within an hour. This is retaliation, he said bluntly. Karen Whitmore is going after you because you challenged her and won. Can she do that, legally? Not if it's retaliatory, but proving retaliation can be tricky. Do you actually have weeds? A few small ones, yes. Nothing major, and I was planning to pull them this weekend anyway. Pull them immediately and document that you've done so. Then I'll file a response claiming retaliation and harassment. If she keeps this up, we'll have grounds for a bigger lawsuit. I spent that afternoon pulling every single weed from my property, even the tiny ones that were barely visible. I took before and after photos, time-stamped everything, and sent it all to Mitchell. He filed another response with the HOA, pointing out that the weeds had been removed within 48 hours of the notice, and arguing that assessing fines for minor, temporary issues that were quickly corrected constituted harassment and retaliation. Karen responded by scheduling another hearing. This time, Mitchell advised me not to attend. Let me handle this one alone, he said. Your presence might inflame the situation. I'll argue that this is a pattern of harassment and demand that the board take action to stop it. The hearing was held a week later, and Mitchell called me afterwards to fill me in. The board had again sided with me, withdrawing the fine and issuing a warning to Karen about retaliatory enforcement. Robert, the gray-haired board member, had apparently told Karen directly that she needed to stop targeting me or face removal from the board. But Karen wasn't done. Over the next 3 months, she issued 6 more violation notices against me. One claimed my desert willow tree had a dead branch that needed to be removed. Another said my house number wasn't clearly visible from the street, even though it was the same house number that had been there when I bought the place. A third cited me for having my trash cans visible from the street on a non-collection day, even though it was trash day and the cans were at the curb for pickup. Each notice was more petty and baseless than the last. Mitchell responded to each one, documenting the pattern of harassment and building our case. Finally, after the 6th violation notice, He advised me that it was time to take legal action. "We're going to file a lawsuit against Karen Whitmore personally and the HOA," he said. "We'll seek a restraining order preventing her from harassing you, and we'll ask for damages and attorney fees. This has gone way beyond a simple dispute about CCRs. She's using her position to wage a personal vendetta, and we need to stop it." I agreed immediately. The constant violation notices had made my life miserable. I was afraid to do anything in my yard, worried that any minor imperfection would result in another fine and another fight. I couldn't live like that. Mitchell filed the lawsuit in Maricopa County Superior Court in early July. The complaint detailed all the violation notices, the pattern of harassment, and the HOA's failure to stop Karen's retaliatory behavior despite multiple warnings. We sued for injunctive relief, emotional distress damages, and attorney fees. The total amount we were seeking was $25,000, plus the cost of all the legal work Mitchell had done. The HOA's attorney, a woman named Patricia from a large Phoenix law firm, reached out to Mitchell within a week of the filing. She wanted to discuss settlement. Mitchell and I met with her in her downtown office, a sleek high-rise with views of the entire valley. Patricia was professional and direct. "My clients acknowledge that Miss Whitmore's actions toward Mr. Nichols have been excessive. The board is prepared to offer a settlement that includes removal of all violation notices from Mr. Nichols' record, a guarantee that no further action will be taken regarding minor or temporary issues, and reimbursement of attorney fees incurred to date." "What about Karen Whitmore?" Mitchell asked. "Will she be removed from the board?" "That's an internal matter for the HOA. I can't make promises about board composition." "Then we don't have a settlement. My client needs protection from ongoing harassment, and that means Karen Whitmore can't have power over him anymore. Either she's removed from the board or we're going to court." Patricia sighed. "I'll discuss it with my clients, but I can't guarantee they'll agree to force out a board member." "Then we'll see you in court," Mitchell said, standing up. We didn't hear back from Patricia for 2 weeks. During that time, I received another violation notice from Karen, this one claiming that I had failed to maintain my irrigation system because there was a puddle in my yard. The puddle was from me watering my plants that morning, and it had evaporated within hours. Mitchell immediately filed a motion for a temporary restraining order, and the judge granted it, ordering Karen to stop issuing any violation notices to me pending the outcome of the lawsuit. That seemed to be the final straw for the HOA board. Patricia called Mitchell the day after the restraining order was issued and said the board had voted to remove Karen Whitmore as president and was considering removing her from the board entirely. They wanted to settle the case for $30,000 plus attorney fees, with a binding agreement that I would never be targeted for minor or temporary issues again. Mitchell brought the offer to me, and I was torn. On one hand, $30,000 was a lot of money, and it would compensate me for all the stress and hassle Karen had caused. On the other hand, I wanted my day in court. I wanted a judge to officially say that what Karen had done was wrong and make her pay for it publicly. "What do you think I should do?" I asked Mitchell. "Trials are always a risk," he said honestly. "We have a strong case, but you never know what a judge or jury might do. The settlement gives you guaranteed money and guaranteed protection, but if you want to go to trial, I'm ready to fight." I thought about it for a few days. Ultimately, I decided I wanted the trial. It wasn't just about the money anymore. It was about the principle. Karen had abused her power and made my life hell, and I wanted there to be consequences. "Let's go to trial," I told Mitchell. He nodded. "Then let's prepare." The trial was scheduled for October, 5 months after Mitchell had filed the lawsuit. In the meantime, The HOA board did vote to remove Karen from the board entirely, citing her violation of the court's restraining order and her pattern of improper conduct. She tried to fight the removal, but the board's decision was upheld by their attorney. Karen then filed a counter-lawsuit against me, claiming defamation and intentional interference with her HOA duties. It was a desperate move, and Mitchell was confident it would be dismissed. The counter-lawsuit did get dismissed at a preliminary hearing, with the judge saying it had no legal merit. But Karen's attorney filed it on to the main case, meaning everything would be decided together at trial. As the trial date approached, Mitchell and I spent hours preparing. He deposed Karen, the other board members, and several neighbors. The depositions revealed that Karen had indeed been targeting me specifically, and that other homeowners with similar minor issues had not been cited. One neighbor testified that Karen had mentioned me by name at a neighborhood party, calling me a troublemaker who didn't respect the community rules. Another said Karen had asked her to take photos of my property and report any violations she saw. Mitchell also discovered that Karen had a history of similar behavior in a previous neighborhood where she had lived. She had been sued by 2 different homeowners there for harassment, and both cases had settled out of court. Mitchell filed a motion to admit this evidence as proof of a pattern of conduct, and the judge agreed. The trial began on a Monday morning in late October. The courthouse in downtown Phoenix was busy, with lawyers and clients hurrying through the hallways and bailiffs calling cases. Our case was assigned to Judge Raymond Thornton, a no-nonsense jurist in his 60s, with a reputation for fairness and impatience with frivolous claims. Mitchell gave his opening statement first, laying out the timeline of events and explaining how Karen had abused her position to harass me over minor and temporary issues. He displayed the photos of my backyard footprints on a large screen, and I could see several people in the courtroom shaking their heads at how minimal they were. Karen's attorney, a man named Douglas who she had hired after her counter-lawsuit was dismissed, tried to argue in his opening statement that Karen had simply been doing her job as HOA president. He claimed that all the violations were legitimate, and that I was a problem homeowner who refused to follow the rules. It was a weak argument, and I could tell Judge Thornton wasn't buying it. Mitchell called me as his first witness. I testified about buying the house, receiving the first violation notice, and all the subsequent notices that followed. I explained how the constant harassment had affected my life, making me anxious and stressed. I described how I was afraid to do anything in my yard without worrying about another violation. Douglas cross-examined me, trying to suggest that I was exaggerating the impact and that the violations were legitimate. But Mitchell had prepared me well, and I stayed calm and consistent in my answers. Next, Mitchell called Robert, the gray-haired board member. Robert testified that he and the other board members had become increasingly concerned about Karen's fixation on my property. He said that Karen had brought up my violations at every board meeting, sometimes spending 20 or 30 minutes discussing minor issues while ignoring more significant problems in the community. He also testified that the board had warned Karen multiple times to stop targeting me, but she had ignored those warnings. The most damaging testimony came from another homeowner named Susan, who lived 2 doors down from me. Susan testified that she had weeds in her yard similar to the ones I had been cited for, but she had never received a violation notice. She also said her decomposed granite path had footprints on it regularly, and Karen had never said anything about it. Mitchell displayed photos of Susan's property next to photos of mine, showing that the issues were nearly identical, but only I had been cited. When it was Douglas's turn to present his case, he called Karen to the stand. She was defensive from the start, insisting that every violation she had issued was legitimate and that she had done nothing wrong. Mitchell's cross-examination was brutal. He walked her through each violation notice, forcing her to explain why I had been cited for issues that existed on other properties without consequence. He confronted her with her statements at the neighborhood party about me being a troublemaker. He brought up her history of harassment lawsuits from her previous neighborhood. By the end of her testimony, Karen was red-faced and flustered, contradicting herself and making excuses that didn't hold up under scrutiny. Judge Thornton was watching her carefully, occasionally making notes. Douglas called one other witness, a landscape architect who testified that the footprints in my yard could be considered damage to the landscaping materials. But Mitchell destroyed that testimony on cross-examination, getting the architect to admit that the footprints were temporary, that they would disappear naturally, and that walking on decomposed granite paths was their intended use. Closing arguments happened on the second day of trial. Mitchell argued passionately that Karen had abused her power, violated my rights as a homeowner, and caused me significant emotional distress through her pattern of harassment. He asked the judge to award me $40,000 in damages, plus all my attorney fees, which had now reached nearly $20,000. Douglas argued that the violations were legitimate and that Karen had acted in good faith. He suggested that any conflict was the result of a personality clash, not harassment. He asked the judge to dismiss my claims and award Karen nothing. Judge Thornton took a recess to review the evidence and prepare his ruling. We waited for nearly 2 hours in the hallway outside the courtroom. I was nervous, running through all the possible outcomes in my mind. Mitchell was calm and confident, assuring me that we had presented a strong case. Finally, the bailiff called us back in. Judge Thornton sat at his bench, looking down at his notes. "I've reviewed all the evidence and testimony in this case," he began. "This is one of the clearer cases of HOA abuse that I've seen in my years on the bench. Miss Whitmore, you were entrusted with authority to enforce reasonable rules for the benefit of the community. Instead, you used that authority to wage a personal campaign against Mr. Nichols over issues that were minor, temporary, and in some cases, completely unavoidable." Karen started to speak, but the judge held up his hand. "The footprints that started this entire dispute were barely visible and disappeared within days. They were the natural result of a homeowner using his property for its intended purpose. Assessing a $250 fine for such a minor and temporary issue was unreasonable and not supported by a fair interpretation of the CCRs. The subsequent violation notices were similarly petty and appeared designed to punish Mr. Nichols for challenging your authority." Judge Thornton flipped through his notes. "The evidence shows that you selectively enforced the rules, targeting Mr. Nichols while ignoring similar issues on other properties. You ignored warnings from your own board to stop this behavior. You violated a court restraining order by continuing to issue violation notices, and you have a documented history of similar conduct in a previous community." He looked directly at Karen. "Your actions constitute harassment, abuse of authority, and intentional infliction of emotional distress. I'm ruling in favor of Mr. Nichols on all claims." I felt Mitchell squeeze my shoulder. Karen sat frozen in her chair. "As to damages, I'm awarding Mr. Nichols $35,000 for emotional distress and harassment. Additionally, under Arizona Revised Statutes Section 33-1807, I'm awarding Mr. Nichols his full attorney fees and costs, which I calculate to be $19,800 based on the billing records submitted. Miss Whitmore, you are personally responsible for paying these amounts within 90 days. Judge Thornton banged his gavel. Furthermore, I'm issuing a permanent injunction prohibiting Miss Whitmore from taking any enforcement action against Mr. Nichols' property, directly or indirectly, for the rest of the time he owns his home in Sagaro Heights. If you violate this injunction, you will face contempt charges. This case is closed. The courtroom was silent for a moment. Then Mitchell was shaking my hand and congratulating me. I felt a wave of relief and vindication wash over me. Karen stormed out of the courtroom without saying a word, her attorney following behind. Outside the courthouse, Mitchell and I stood in the warm Phoenix sunshine. That was a complete victory, he said. The judge didn't just rule in your favor, he made it clear that Karen's conduct was way out of line. And making her personally liable for the damages and attorney fees sends a strong message to other HOA board members who might be tempted to abuse their authority. I still can't believe this all started over footprints in my backyard, I said, shaking my head. HOA disputes often start with something small and spiral out of control, but you stood up for yourself and you won. That takes courage. I couldn't have done it without you. Thank you for everything. We said our goodbyes and I drove home to Scottsdale, feeling lighter than I had in months. The nightmare was finally over. Karen did try one more thing. About a month after the trial, she filed an appeal of Judge Thornton's decision. Mitchell told me not to worry, that appeals of trial court decisions rarely succeeded, especially when the judge's findings were so thorough and well supported by evidence. The appeal was heard by a 3-judge panel in the Arizona Court of Appeals in Phoenix. The appellate court issued its decision in January, 4 months after the trial. The decision was short and to the point. The trial court's ruling was affirmed in its entirety. The appellate judges found no error in Judge Thornton's analysis or conclusions. Karen's appeal was denied, and she was ordered to pay an additional $5,000 to cover the costs of the appeal. By that point, Karen had put her house up for sale. I learned from neighbors that she was moving to New Mexico to be closer to her daughter. Good riddance, as far as I was concerned. She sent me a check for the full amount of the judgment in February, apparently having liquidated some investments to come up with the money. I deposited the check and finally felt like the chapter was truly closed. The HOA board elected a new president, a reasonable woman named Dorothy, who immediately instituted reforms to prevent future abuse. The board adopted new policies requiring multiple board members to sign off on any violation notice, establishing clear guidelines for what constituted a legitimate violation, and creating an independent appeals process. Dorothy personally apologized to me at a community meeting and assured me that I would never face harassment again. Life in Sagaro Heights returned to normal. I could work in my yard without fear, water my plants without worrying about footprints, and actually enjoy my home the way I had intended when I bought it. Some neighbors who had been afraid to talk to me during the dispute started coming by to congratulate me on standing up to Karen. I learned that several other homeowners had received questionable violation notices from her over the years, but had been too intimidated to fight back. My case had apparently freed them from that fear. I used part of the judgment money to make some improvements to my property. I installed a beautiful fountain in my backyard, added some new native plants, and built a small patio for outdoor dining. Every time I looked at those improvements, I thought about how close I had come to losing my house over something as stupid as footprints. Mitchell and I stayed in touch. He sent me a bottle of good scotch when the appellate decision came down, and we met for drinks to celebrate. He told me he had taken on 3 more cases against Sagaro Heights HOA for other homeowners who had been mistreated during Karen's tenure as president. All 3 settled quickly once the HOA's attorney saw the precedent from my case. About a year after the trial, I was featured in a local news story about HOA abuse and homeowner rights. The reporter interviewed me in my backyard, and I walked her along the same decomposed granite path where the footprints had been. The story aired on the evening news and got picked up by some national outlets. I received dozens of messages from people around the country who had their own HOA horror stories. Many of them had been too afraid or too overwhelmed to fight back. I encouraged every one of them to stand up for their rights and not let bully board members intimidate them. The whole experience taught me several important lessons. First, HOAs can be useful organizations, but they're only as good as the people running them. When petty, power-hungry individuals get control, they can make life miserable for everyone. Second, rules and regulations are meant to serve a legitimate purpose, not to be weapons for personal vendettas. Third, standing up for yourself matters even when it's difficult and expensive. If I had just paid that first $250 fine, Karen would have kept coming after me, and I would have lived in fear the entire time I owned my home. I also learned that the legal system, despite its flaws, can work when you have good representation and a fair judge. Judge Thornton's decision wasn't just about my case. It sent a message to HOAs across Arizona about the limits of their authority and the consequences of abuse. I like to think that other homeowners benefited from my willingness to fight. My house in Sagaro Heights is still my dream home. The mountain views are still spectacular, the sunsets are still breathtaking, and my desert garden thrives in the Arizona heat. I walk on my decomposed granite path every day, and sometimes I smile thinking about those footprints that started everything. They were just marks in the dirt, gone in a day or two, but they represented something larger: the right to use and enjoy your own property without unreasonable interference. Karen's legacy in the neighborhood is one of caution and reform. The new board is careful, transparent, and reasonable in their enforcement actions. Homeowners are treated with respect, and violations are issued only when truly warranted. The community is actually more harmonious now than it was before my dispute with Karen, probably because people aren't living in fear of arbitrary fines and harassment. I ran into Karen once, about 6 months after the appellate decision, before she moved away. It was at a grocery store in Scottsdale. We made eye contact across the produce section, and for a moment I thought about just walking away. But instead, I nodded politely. She glared at me and turned away, pushing her cart in the opposite direction. I felt a twinge of something, maybe pity, maybe satisfaction, but mostly I just felt glad that chapter of my life was over. The whole ordeal, from that first violation notice to the final appeal decision, took about 18 months. It was exhausting, stressful, and expensive, even with the attorney fees being covered by the judgment. But it was also empowering. I had stood up to someone who tried to bully me, and I had won, not just in court, but in the broader sense of refusing to be intimidated or silenced. I tell my story to anyone who asks, because I think it's important for people to know that HOA board members aren't dictators, no matter how much some of them might act like it. There are laws, procedures, and protections for homeowners. You don't have to accept abuse just because someone has a title and a gavel. You have rights, and those rights matter. Looking back now, I'm grateful for the whole experience, as strange as that might sound. It taught me about resilience, about fighting for what's right, and about the importance of good legal representation. It also taught me that communities work best when power is checked and balanced, when rules are applied fairly, and when people treat each other with basic respect and common sense. My decomposed granite path still gets footprints on it regularly. I water my plants, I walk through my garden, I live my life. Sometimes after a rain, the footprints are more visible, little impressions in the dampened material. I look at them and remember how absurd it was that anyone thought those temporary marks warranted a fine, let alone a legal battle that went all the way to the appellate court. But those footprints also remind me of something important. That I walked where I had every right to walk, that I stood where I had every right to stand, and that when someone tried to tell me I couldn't do those basic things in my own home, I fought back and won. That's worth remembering, and it's worth fighting for, whether it's about footprints or any other overreach of authority. The judgment money, after paying Mitchell's fees, left me with about $35,000. I put most of it into savings, but I also donated $5,000 to a local nonprofit that provides legal assistance to homeowners in disputes with their HOAs. If my case could help other people avoid or fight back against similar situations, that seemed like money well spent. Mitchell told me later that my case had become something of a reference point in HOA law in Arizona. Attorneys representing homeowners were citing Judge Thornton's decision in their briefs, and some HOAs were revising their policies to avoid similar liability. The case had even been discussed at a conference of community association attorneys, where it was held up as an example of what not to do. I never sought fame or attention from any of this. I just wanted to live peacefully in my home without harassment. But if my experience has helped create better standards and protections for other homeowners, then something good came out of all the stress and conflict. These days, when I'm working in my yard or sitting on my patio watching the sunset, I sometimes think about all the people who might be dealing with their own Karen Whitmores right now. HOA board members who have let their small amount of power go to their heads, who see violations where there's just normal life happening, who use rules as weapons instead of tools for maintaining community standards. I hope those people find the courage to stand up for themselves, to say no to unreasonable demands, and to fight back when they're being treated unjustly. The legal system isn't perfect, and fighting an HOA isn't easy or cheap. But it's possible, and sometimes it's necessary. My case proved that judges will stand up for homeowners when the HOA's actions are clearly unreasonable and motivated by personal animus, rather than legitimate community concerns. That's an important precedent, and I'm proud to have been part of establishing it. In the end, this whole saga was about something much bigger than footprints. It was about the right to live in your own home without fear, the right to use your property for its intended purpose, and the right to be treated fairly by people in positions of authority. Those are fundamental rights, and they're worth defending, no matter how trivial the initial dispute might seem. I still live in Scottsdale, still love my home in Saguaro Heights, and still serve on the Architectural Review Committee for the HOA, working to ensure that enforcement actions are reasonable and fair. Dorothy, the new president, welcomed my perspective, saying that someone who had been through what I experienced would be valuable in making sure others weren't subjected to similar treatment. The experience changed me in ways I'm still discovering. I'm more confident in standing up for myself, more aware of the importance of documentation and evidence, and more committed to fairness and due process in all aspects of life. I'm also more sympathetic to people dealing with difficult situations involving authorities or organizations, knowing how powerless you can feel when someone with institutional power is targeting you. Sometimes new neighbors move in and ask me about the HOA, whether it's reasonable or difficult to work with. I tell them honestly that it went through a rough period, but that it's much better now. I also tell them to document everything, know their rights, and never be afraid to push back against unreasonable demands. Most of them look at me curiously, and sometimes I'll share the story of the footprints and the lawsuit that followed. Their reactions range from shock to amusement to anger, but everyone agrees that what Karen did was outrageous. Life has a way of teaching you lessons when you least expect them. I never imagined that buying my dream house would lead to an 18-month legal battle, but I also never imagined I would come out of it stronger, more informed, and more committed to justice and fairness. The footprints that Karen tried to find me for have long since disappeared, washed away by rain and smoothed over by time and use. But the impression of that experience, the lessons I learned and the principles I defended, those are permanent. They're imprinted on my character, just as surely as my shoes were once imprinted on that decomposed granite path. And unlike those footprints, these marks will never fade.